We have counsel for both parties before us. Attorney Besviznik, could you tell me if you intend to reserve time?
Yes, Your Honor. I'd like to reserve 3 or 4 minutes. 4 minutes.
4 minutes? Thank you. I will try to be discreet when I interrupt you to send you that message. See if I can get lucky and get the right time. We are then ready to proceed. Counsel, please go ahead.
Thank you. Thank you, Your Honor. May it please the court, my name is Laura Besviznik, and I represent the petitioner on this petition for Certiorari American Home Assurance Company. Not the first time this case has been before this court. No,
I know who wrote on the last one.
Yes, Your Honor. But we're here on a different issue this time. We were previously before this court addressing work product issues under Allstate versus Ruiz in the insurance context. We're here on a different issue today, and I would suggest a different result is required. The issue that this really is presented is the continued viability of the attorney-client privilege for insurers in coverage and bad faith disputes. The Florida Supreme Court, as it addressed—
Did the trial court make an express holding that there is no such thing as attorney-client privilege in this proceeding?
Not directly, Your Honor, but implicitly. What the court—
Well, I'm concerned, and let me articulate it because it may touch other parts of your presentation.
Yes, Your Honor.
My understanding is that we have limited powers under cert. I think Judge Northcutt wrote an opinion back in Nucci, which cited the Supreme Court's footnote 18 in another case that says all we have the power to do is to deny the writ or quash the order under review. We don't have the ability to take any action that results in the entry of the judgment or a change in the order on appeal. So if that is the limit of our power, and I don't see an express provision in, I think it's Judge Brody, right? Judge Brody's order that says there shall not be. How do I address specifically, strike that, how do we address specifically the issue you present before us, even, and assume it's meritorious, how do we have the authority to get there?
Well, Your Honor, I would say 2 things. One is the court ordered that specific documents be produced based on its interpretation of Genovese and the application of the attorney-client privilege to these documents that were reviewed in camera. That's the first issue. So there is a direct application of the attorney-client privilege or failure to apply the attorney-client privilege to specific documents. And I want to be very clear, the 200 documents that were identified as the sampling of documents for in-camera review are a part of this court's record. And they were filed confidentially, obviously, because they're confidential from the other side at this juncture. And the court can see the nature of the documents that the court specifically held should be produced because they were not privileged. And so I think that that puts this squarely within Your Honor's cert jurisdiction, because were the court to decline to reach this issue, this is a classic cat out of the bag problem in terms of those documents being required to be produced. Now, the specific rulings on the sample documents were based on the holdings that we address in the briefing. So if Your Honor, if that responds to your, and there's a second issue in the case as well, which is the scope of the in-camera review that was conducted, which was very limited, and the holdings of this court that require in-camera review. And in that regard, this court clearly has jurisdiction to say, go back, Judge Brody, go back, Judge Barger, do it again, look at these documents and conduct the appropriate in-camera review.
And when you say look at these documents, you are referring to the documents that appear on page 2 of the trial court's order that incorporate the attachment to the magistrate's proposed order?
In part, Your Honor, what happened was in the first order that was entered that we were previously in front of.
Can I interrupt for just a second? Is the nut of what you are asking us to send this back, and I know you asked, you had a colloquy with the trial judge, and she asked you, are you suggesting, you were suggesting perhaps a special master to review individually the entire universe of, I think, 3,500 documents. Is that right?
I want to answer your question directly. The answer is yes. I think that's what would be required, particularly given the arguments about why the plaintiff argued and why the court agreed that certain of these documents were not privileged. It really requires a substantive review of the specific text of the documents because
Of
of the
each of
argument.
the 3,500.
Whether there may be ways to classify it, what happened was the court ordered for there to be 200 sample documents, but there was no sampling methodology. They were just picked. And so they were not in specific categories. So whether there's a possibility of creating categories with something that we might be able to explore with a special master, but in a circumstance where the argument is, this isn't legal advice, this is business advice, that really requires looking at the substance of the individual document.
And so let me ask you two follow-up questions quickly. Sorry to derail your response to Judge Castaneda. We are talking about 3,500 discrete documents. Is that right?
I don't have the exact count, Your Honor.
That's in the ballpark, though.
Because of this scope of when these documents were created, which is during 13 years of litigation, there are a number of documents. So
what I'm driving at is you all set for trial in a little more than 2 months, right?
That is correct, Your Honor.
And your home run bases loaded here is we issue the writ and with instructions to have the trial court appoint a special master to review at least 3,500 documents before they're produced.
I think that's required by this court's case law, but I also believe.
Well, let me pause you there. Where do we get that authority on a petition for writ of certiorari to issue an order compelling the trial judge to enter an order based on the language of the Supreme Court's footnote 18 and our case that I just cited? It says we're limited to either dismissing the writ or quashing the order, not entering a new one. And on this order, the second page says, the rest of the documents need to be produced and a privilege log accordance to it, which seems to be in compliance with other decisional law. We don't have a holding that says, I won't appoint a special master. We don't have a motion to appoint a special master. So you're asking us to issue a trial court ruling or a mandate that I'm not sure we can do on cert.
Your Honor, I'm not asking you to direct I want to be clear. I'm not asking you to direct the court to appoint a special master. I'm asking you to quash the order that's under review.
Okay,
In
so
its entirety.
if we're to quash the order, what part of the order, paragraph 1 that says these are to, I approve the special master, they are not bound by attorney-client privilege. The next paragraph 3 says 60 days, give us all the other documents and a privilege log so that basically the trial court can rule. So which of these two orders am I to quash?
Your Honor,
Or this panel is to quash, pardon me.
I'm sorry, Your Honor, I just want to be clear and respond to your question directly. And I'm looking at the recommended order on in-camera inspection that was affirmed by and adopted by.
The trial court specifically entered an order. I approve in general language and in specifics, paragraph 2, these documents will be produced. And in paragraph 3, all other documents that are not encompassed here, we have a claim of privilege, give us a privilege log. That's exactly what the circuit court did if I read her order correctly. It doesn't say the rest are all out of the bag. It doesn't say the rest are not there. There is, give me a claim of your privilege. Now, I feel a lot of sympathy if I'm the special master and I have to go through all the rest of these documents all by my lonesome, but I'm not sure that that's before us today. And I want to make sure on this writ case that I know exactly what I'm looking at. And it appears to be operative paragraph 2 and operative paragraph 3 of Judge Brody's order.
I understand what Your Honor is saying. If I could direct your Honor respectfully to paragraph 1 of the order, which says the exceptions are overruled. The court hereby approves and adopts the recommended orders of the magistrate dated March 5, 2021 and April 23, 2021, attached as exhibits A and B. the legal arguments regarding the scope of the attorney-client privilege and the application of Genovese to these documents in terms of whether what the magistrate did and what the court affirmed effectively applied a work product analysis to these privileged documents by looking at relevance and need, and whether the court took an inappropriate application of Genovese by treating what was directly core attorney-client privilege legal advice relating to the SIBO litigation and treated it as if it were business advice because this was an insurance company. Those holdings are directly before your honors under paragraph 1 of the Judge Brody's order adopting the magistrate's recommendation. Those rulings were then applied to the documents specifically listed in the second paragraph of the order. The third paragraph of the order, and I just want to be clear about this, that because of the way the magistrate ruled in terms of looking at only a subset of the documents, it was directed that we, my client, look at the documents that we had in good faith withheld on the grounds of attorney-client privilege in the first instance and say, well, based on your honor's rulings, which are the rulings that were before you challenging today, go back and look again at the documents you withheld on privilege grounds and produce the ones that, based on my current order, you should be required to produce. And if there are any that you think are still privileged, notwithstanding the order that was entered, you can put those on a privilege log. So the problem we have is the legal underpinnings of that first paragraph of this order, which is the issues with respect to relevance and need, and the problem with legal advice to an insurer being treated as business advice simply because they are in the business of providing insurance. So that is the reason, Your Honor, that we think this is a proper cert petition that puts these legal questions directly and properly before the court with respect to these critical attorney-client privilege issues under Genovese. So if I can proceed then to talk about, and if I have any other questions on that, I'm happy to respond to them, Your Honor. But that was the nature of the order, which was, these are my rulings about attorney-client privilege. Within the small sample that I reviewed, I want you to produce these. You don't have to produce those. And then once we apply that, I want you, American Home, to look at the documents again and decide based on my rulings, which things are no longer privileged based on the legal rulings I've set before you, which is why we're before you here today to talk about those legal rulings, which we believe are facially incorrect under Genovese and under Allstate. That, as Judge Castanway noted, under Allstate versus Ruiz, the work product is gone in the first party bad faith context. The attorney-client privilege under Genovese is very squarely not gone. What the Supreme Court held in Genovese was that insurers are entitled to assert the attorney-client privilege when they receive legal advice, and that privilege continues through the first party bad faith context. This case is particularly, it's very unusual in the following respect. What Genovese was concerned about and talked about at length was in the issue between legal advice and whether there's business advice being provided, the recognition that sometimes lawyers are hired to investigate a claim and render legal advice. That's not what happened in this case. American Home hired lawyers after the decision was made to deny coverage and after Mr. SIBO had filed his lawsuit against American Home. All of the documents having to do with the phase leading up through the denial of coverage produced. Attorneys were not involved. Those documents were produced. These are documents in the main that are communications between litigation counsel for an insurance company and the insurance company and its in-house lawyers regarding an ongoing litigation. It is what is in most circumstances considered to be the core of the attorney-client privilege. But what was argued and what Judge Barger held and that Judge Brody approved was that when, during the course of that litigation, the lawyers talked about coverage or coverage advice in terms of the law governing coverage, because that's what the case was about. And it went to the Florida Supreme Court. So it was a very long period of time and a lot of lawyers were involved. But it was about legal issues. And that is the core of the attorney-client privilege, those communications between the lawyers and the insurance company. And the argument that was made and the argument that was accepted by Judge Barger and accepted by Judge Brody is that in coverage litigation, if the lawyers are talking about coverage with the insurance company, that somehow that's business advice. And it's business advice because the insurance company is in the business of insurance coverage. And what I would submit to you is every business is in some business. Automakers make automobiles. Pharmaceutical companies sell drugs. In connection with their business, they get legal advice. When they are sued in lawsuits, they have to hire lawyers to defend them. They're corporations, they can't defend themselves. The argument here that an insurance company can't hire a lawyer and have privileged communications with them during the ongoing litigation against their adversary, who in this case was Mr. Sebo, who was also the insured, but is most assuredly a litigation adversary, is wrong. And there's no basis for it, and it's directly contrary to Genevieve. The argument that because somehow the claims handling process continues through litigation, that it makes all litigation communications fair game. If that were true, it would be directly contrary to Genevieve, and it is. And that is the problem. And what we see in the in-camera, the limited in-camera review that was conducted, and I would encourage your honors, if you have not already, to look at some of the documents that the magistrate held and that the judge approved as being not protected by the attorney-client privilege. Because I would submit to you that in any other circumstance, if your honors were to look at those documents, you would see that they were privileged. And that is, Judge Casanueva, squarely the subject of this petition for cert.
I'm glad you raised that point, because I have gone through this record and this coding system that appears to try to locate the documents and read them. And it causes me to raise the following question. Where in the briefing is the court here directed to look at a particular document and impose why and analyzes why that is attorney-client privileged, other than the generic arguments we've been making, look at it? And I don't want to quote Justice Potter Stewart that I know when I see it. Sometimes I want to be helped by counsel and be led down the right path before I go all by myself. Are there arguments in the brief that specifically identify certain documents and the specific passages to which you are referring to? Because I read so much, I'm scared I might have missed it. I'm concerned I might have missed it.
Yes, Your Honor. I'm going to look for the page in the brief now.
Okay, if you want to do it on rebuttal, that's fine.
I will.
I don't want to invade your time for that, right now.
There are several documents, and I would only caveat it in this way, Your Honor, which is I can't talk about the substance of the documents.
I'm looking like, go to paragraph 2, first word this, last sentence that, the contents between those lines, so I know exactly, like a pinpoint citation. And I don't want to read it to you either, except, I've got some copies, if you will, of the documents that I tried to go through and read them all so that I could perhaps for once ask an erudite question. I appreciate you bearing with me.
I actually,
and I need to tell you that because of my conversation, we've taken you past 17, but I don't want to invade any more of your rebuttal time.
Then I'll come back, Your Honor, on rebuttal and provide you the citation to where we know documents.
If it's in the record with the magistrate or whatever, because I went through the briefing, I went through the emails, but I wanted to make sure I had all the right precise documents and the questionable, the ad issue language. So thank you. Even if it's just one or two, not all of them, just give me a little direction. With that, I will stop chatting and we will go to, excuse me, counsel for Mr. Sebo. Mr. Weaver, I believe the floor then would be yours.
Thank you, Your Honor. Good morning, and may it please the court. Matt Weaver again on behalf of the respondent, John Robert Sebo. I want to first address sort of where we are with this issue. Judge Castanueva, I'm sure you recall our prior engagement on this. We're here on a cert petition by American Home. In order to grant that cert petition, there must be a departure from the essential requirements of law. So I want to start with the law, and the law is.
Well, if there's an attorney-client breach, wouldn't that be a requirement of law that cannot be remedied on a direct appeal because it would be out, so to speak?
If there is an order requiring production of a document that is protected by the attorney-client privilege, I agree with you. I think the issue here, as Ms. Besvinick alluded to, is really the scope of the privilege. And Genovese really is the keystone to this analysis. And I want to be very clear. We have never argued what the insured argued in Genovese, namely that there is some need-based exception to the attorney-client privilege that exists in bad faith cases. Now, this was what the Ruiz case was all about, and this is what our first trip on privilege issues to this court was about. We have never made that argument. We have never once contended that there is not a privilege that is enjoyed by American Home. The issue has always been and remains the scope of that privilege and whether certain documents are, in the words of the Genovese court, truly protected by the attorney-client privilege in light of what the Ruiz court and this court have said about work product immunity. So it's that framework in which we find ourselves. And that's really why these issues, I think, can be very difficult for a trial court or a general magistrate trying to conduct an in-camera review. I didn't hear, to your question, Judge Castanueva, I didn't see anything argued in briefs or heard today about specific documents or specific issues with the 25 or so documents that General Magistrate Judge Barger ordered produced. What I heard were categorical issues with the scope of the privilege. And really, I think where this is really headed, and I think what the nub of the issue is where are we now in this case? What did Judge Brody in her order leave the parties with as to this issue? And I think, Judge Castanueva, you alluded to this in your question. That order, which adopts the recommendations of the general magistrate, is not a requirement to produce any document beyond the 25 documents that the general magistrate specifically identified. If you read the motion or the order on motion for clarification that was brought before the general magistrate, which appears at page 19 of the appendix, you'll see that her intent was to give an in-camera review of the sample documents. Here, each side had 100 or so documents that they submitted. And her intent was to make rulings on a selection of those that were then to guide American Home in its efforts to go back and reevaluate its own privilege positions on remaining documents. There was never an order, and I studied the record very carefully on this, there was never an order requiring American Home to produce anything beyond the 25. So where does that leave us? The only, I would submit, and I'm at a disadvantage that Ms. Besvinick, obviously the court, has access to these documents and can evaluate privilege claims individually. I obviously don't have that ability. But to the extent there's any issue with the documents that were ordered and produced, I would submit that's the only ground on which this court could grant cert. On the protocol and the sampling issue, I just want to be very clear. As Mr. Sebo's counsel, we don't take this issue lightly. And we have never contended that every single document that is withheld on the privilege logs that American Home produced is subject to discovery because there is no attorney-client privilege. So what did we do? And Ms. Besvinick, counsel for American Home, agreed to this procedure. What did we do? We've tried to figure out a way for the court to give us a representative sample and guide the parties further conferrals on this. That's where the sampling protocol came about. We've cited cases to the court in our briefs where this is a common practice in complex cases where you have large amounts of potentially privileged or immune documents. Certainly, there's no case that American Home has cited which suggests such a procedure departs from the essential requirements of law. This was an issue that on the original motion to compel, way back in April of 2020, Magistrate Judge Barger identified, and I'm going to read now. This is at page 1166 of the appendix. This is the hearing transcript on that motion to compel. After argument on mainly work product issues, the court asked this question. I do have a question for you. In the event that I rule that an in-camera inspection is necessary, does anyone have any ideas on how that's going to be feasibly done? Counsel for American Home answered, as you gathered, it's a pretty voluminous group, and I'm assuming you don't want to look at all of them, meaning all of the documents. So perhaps the parties could get together and figure out something that you might propose to Your Honor in that regard. That's exactly what happened. So again, down the line, what did we do as counsel for Mr. Sebo? We picked 100 documents that we thought might be either not privileged based upon the review of the privilege logs or a borderline call, something that we needed guidance from the portal. American Home picked 100 documents based on its choice. There was no, I guess, ordered upon method or agreed upon method for what documents would be selected. The parties were given discretion in that regard, but this was always intended by both parties to be a process that would lead to further conferral. And further briefs and further positions taken by American Home drive that point home. When American Home took exceptions to the very first order of the general magistrate, this is back in 2020, this is the order on work product. American Home made clear that it had no objection to the portion of the ruling that ordered in-camera review. It reserved its right. I'm reading again. This is page 969 of the appendix. American Home reserves the right to timely take exception to any recommended order issued following the in-camera inspection. Well, the order establishing the in-camera inspection had already been issued. That was actually the order that this court looked at the first time around back in the initial appeal on work product. Even in the exceptions to the order requiring production of these 25 documents, American Home says, this is page 771 of the appendix, it is unclear whether the recommended order is intended to require the production of any additional documents by American Home. To the extent it is, American Home takes exception. We've never contended that it is. And the magistrate in her motion for clarification didn't contend or intend that her order be such an order. So that's where we're left with. On the issue of the scope of the privilege, Genovese makes clear that the attorney-client privilege applies to communications or documents which reflect the contents of communications. In other words, a lawyer might write an email to a client giving legal advice. That client might then forward that email along to someone else. That's still a privileged email. Or the client might comment on the nature of the discussion in such a way that reveals the contents. That's still a privileged communication. It's entitled to protection. We've never argued otherwise. The issue about legal and business advice, I heard a very similar argument from my counterpart on this issue to the one that was made the first time around in front of this court on the work product issue. It's really a relevance argument, and it's an argument that calls to mind certain defenses that American Home may or may not have in the case. It's not an argument that suggests that there's anything improper about the trial court's order that departed from the essential requirements law on privilege. So I would stand on our papers on that issue. Again, I think Judge Casanova, just to briefly sum up on the point regarding the scope of cert relief, the Supreme Court in Patton, when dealing with the issue of production of billing records, it said, we're not here to, on cert relief, to sort out disagreements. We're here to fix orders that depart from the essential requirements of law and lead to the production of so-called cat out of the bag discovery. The protocol issue isn't that type of order. That part of the court's order isn't that type of order. And I think, Judge LaBritte, to your sort of practical point about the trial date, yes, we're about 2 months out from trial. The case has been continued once, and we fully intend to see this trial date through if possible. I would suggest that it be made clear that at this stage, at least Mr. Sebo was entitled to those 25 documents that the magistrate and Judge Brody ruled he was entitled to. And beyond that, we would ask that the petition be denied. Thank you.
Thank you, counsel. Give me a second to update my notes and stop the clock. Counsel Besvinick, you have the floor for your remaining time.
Thank you, Your Honor. Before I forget, I want to respond to the question you left me, which is
Thank you so
where in the
much.
briefs did we address any individual issues? And at page 28 of the petition for certiorari, going on to page 29, we identified several examples from the list as indicative of why these are attorney-client privilege issues within the scope of what we could say.
All right,
obviously,
I'll reread that again. Thank you so much.
Thank you. And it identifies that these are communications between counsel and specific people at American Home, and identifies those. So I want to, in my limited time, just talk about the structure of this order and why we're here on cert. For the reasons that we've set forth, I think in a very straightforward way in the briefs, we believe that the substantive rulings of the magistrate on the scope of the attorney-client privilege and its application to the specific documents that were in front of her is wrong. So that's the first paragraph of the order, are the legal holdings that underpin the decision about which documents should be produced. We are challenging those, and we are properly challenging those we submit. Second, there are specific documents based on that ruling and the limited sample that was reviewed that the magistrate ordered produced. That's the 25 or 26 documents in paragraph 2 of the order. We are challenging those as improper, both specifically and based on the rulings, the legal rulings underlying that decision that's before Your Honor. So we believe those documents are properly before Your Honor and included before Your Honor and are in the record. Third, the third paragraph of this order says, within 60 days of the date of this order or the final disposition of a petition, defendant shall produce all additional documents withheld on attorney-client privilege grounds that are required to be produced in accordance with this order. That's not the 25. That's the rest of them, consistent with the legal rulings that we believe to be a departure from the essential requirements of law.
Well, in paragraph 3, the order specifically says produce all additional documents that are required to be produced in accordance with this order. So we've got the 25. And as to the rest of them, the court directs the provision of an updated privilege log. So is it fair for us to confine our review to the 25?
If I could, Your Honor, there's 2 parts to the order, and I think this is maybe, it may be confusing. It wasn't to the parties, but let me explain this. Paragraph 2 of the order requires the 25 documents to be produced within 20 days. Paragraph 3 of the order is dealing with all of the rest of the documents. Paragraph 2 of the order is the one that deals with producing the 25. It says produce those within 20 days. Paragraph 3 says produce everything else that we haven't looked at, because we want you, and the reason it gives more time is it says you, American Home, now have to take these legal rulings and apply them to the rest of the universe of the documents. And only if you think some of them still aren't privileged based on this legal ruling, those are the ones that go on a privilege log. So the problem is each paragraph of this order is based upon what we contend is an essential departure from the requirement, a departure from the essential requirements of law, namely the application of Genovese and the scope of the attorney-client privilege to these documents. And additionally, the procedure with respect to in-camera review. And I have to disagree with my colleague on.
I'm sorry, I have to, just to get clarification on what you're saying about this order.
Yes, Your Honor.
Your interpretation of the order is that paragraph 3, Romanet 2, is that the language in accordance with this order means that you can only assert attorney-client privilege as you say the trial court has incorrectly circumscribed it,
Correct, Your Honor.
as opposed to, in accordance with this order, provide an updated log for any documents withheld on attorney-client privilege grounds in accordance with this order. So your view of it is, in accordance with this order, superimposes what you say is the erroneous ruling on Genovese and the Allstate case.
Yes, Your Honor.
Okay.
That is my
Thanks.
understanding of the order, because paragraph 2 expressly deals with the specific 25 documents and requires their production within 20 days. And so the instruction of paragraph 3 is apply my rulings to everything else. And I know my time is essentially up, but I did want to just respond to one thing that my colleague, Mr. Weaver, said. The parties never conferred regarding a sampling protocol. The judge directed that the parties confer regarding a sampling protocol and pick 200 documents. Mr. Cebo's counsel said, we're not agreeing to a protocol, we're going to pick 100. And so that's what happened. There was not an agreement. And as we've cited from the transcript before Judge Brody, we expressly asked her to require a complete in-camera review. So thank you, Your Honor.
Thank you, counsel. Thank you both. Well presented. Have you ever wondered where the phrase cat out of the bag came from?
Yes.
There are some people that says it refers to a cat of 9 tails that used to be on board the old sailing vessels in the 1800s. And they were wrapped up before the voyage as a indicator of the captain's powers. And they did want it pulled out of the bag in which it was stored, because then it would draw blood. At least that's one alleged historical statement for that one. And I draw upon the works of a Dudley Pope for that little piece of nautical history for you. And we wish you well. And I know that that this will be my last contact with this case, but perhaps Judge Stargell will get to see it in its next development. And until then, we wish you well and good health. And thank you very much for your presentation today.
Thank you.
Your Honor.
All righty, that's it. Well,